Hi, and welcome to our Donahue, O'Connell, and Riley video series on important topics in estate planning and administration. Today we're going to talk about what happens when a loved one passes. There are a lot of misconceptions out there about the estate administration process, and there's also a lot of things that you can do leading up to the passing of a loved one that will make the estate administration process more straightforward, less expensive, and less time consuming. So let's start from the top. One of the things you're going to get when you come into our office is this very useful checklist, and you can download this on our website. We'll put a link in the description below. And it divides estate administration into 5 key phases. And those 5 phases are really what drives the timeline associated with an estate administration or a trust administration. Generally speaking, there are 2 primary factors that will determine the complexity and length of estate administration. The first is engagement with the court system, which can be avoided through the use of trusts by and large, and secondarily, tax compliance. We always tell clients that if you pass away at the end of a tax year, chances are the estate administration, if you die in October or September even, it's not going to be done by the end of the calendar year. And this will lead to assets being either sold or gains or losses or dividends or interest being realized in the following taxable year. So if the estate accrues income in January, $600 or more, you're not going to be able to close out that estate until the following year when you can file a tax return for the year in course. So always keep your eye on that calendar. There are some ways that you can choose a fiscal year, but something we generally don't do because 1099s and other tax documents are issued by investment advisory firms on a calendar year basis rather than on a fiscal year basis. So when you come in, the most important thing to have with you is a list of beneficiaries, their names, addresses, and if you can get them, telephone numbers and social security numbers. Those are going to be needed for tax compliance down the road. And then a list of assets. For many people, they have a house, a piece of real estate they own, condominium, investment accounts. Some are retirement accounts, some are after-tax investment accounts. They often have a checking or savings account, and having recent statements from those accounts can be a great place to start. Going through this checklist, that initial intake, we're going to be gathering key information both about the person who has passed, but also about the people who are eventually the beneficiaries of an estate. In order to commence an administration, we're going to need a death certificate, probably several copies. You want to bring at least one for each account and each asset. So if there's a car that needs to be transferred, an account that needs to be liquidated, get at least that many death certificates, plus one for the file, the law firm, probably a couple for the court, maybe some for tax authorities as well. So if you have 5 accounts, maybe you want to get 10 death certificates as a good starting place. Depending on whether or not the person died with a trust or whether there's going to be a probate administration, the next phase is usually preparing a probate petition. And a probate petition is the document that we send to the court to have someone appointed to act as executor of the decedent's estate. This, depending on where you live, can be a more or less complicated process. And there are different nuances from state to state and even from county to county. So you want to work with your attorney and someone who's familiar with the jurisdiction where you're going to be submitting the probate petition. Usually once the client comes in, we give them some homework that we need to get some data on the various individuals that are involved in the probate. They come back to us, and it takes us a couple weeks to prepare the petition. And then depending on where you're at in what jurisdiction, you can get letters back, letters testamentary, this appointing someone as an executor, in as little as a few weeks. Or sometimes it can take over a year. Some courthouses are more backed up than others. We tend to find that Courthouses in large cities are the ones that are often the most behind. So if you have a probate in Manhattan, that can take a lot longer than one, let's say, in Orange County or up in Carroll County in New Hampshire. Uh, After the petition has been submitted, we're often in a waiting period. And usually what we'll do for our clients is schedule a time to come back and review the status of the petition. If we get it a little earlier, great. And if we don't have it by the time that appointment has been set, we can always reschedule that. But we always like to keep a nice pace to the petition, to the probate process, and have people back in on a regular basis. Once letters of administration have been issued, or if there's a trust involved, once you've accepted an appointment as trustee, you can begin to marshal assets. This is the process of gathering assets from different sources, liquidating them, and putting them in an account for the trust or the estate. Your attorney is going to get a new taxpayer identification number for the estate or the trust, or perhaps both, and assets will gradually be consolidated into a single account. Typically, unless there's a privately held business or a portfolio that's going to be distributed in kind, in other words, the actual individual stocks will transfer, we generally advise executors to liquidate so that fluctuations in the portfolio don't affect the amount of money that's going to be given out to the beneficiaries. It also helps to reduce tax compliance requirements. If you can get everything liquid in a non-interest bearing account by the end of the tax year, that means not having to file a return in the following tax year. So being efficient and as possible when liquidating assets is a real important step that will simplify the administration. The next step is going to be paying any debts of the decedent. This could be something as final medical and funeral expenses, might be some credit cards outstanding, and often people have ongoing bills that need to be paid, such as utilities, telephone bills, cable bills, keeping the lawn mowed and the leaves raked and the snow plowed is an important part of the executor's job. And those costs can add up quite substantially. Common misconception is that there's going to be some sort of reading of the will. That's an artifact from the movies, from the days when people were illiterate and there were no photocopiers. Nowadays we just send people copies of things in the mail. And most estate administrations, even ones that go through probate court, don't require an appearance in court, which is great. It's a fairly streamlined process in most jurisdictions. If you have a trust, you can bypass the court entirely. Many times we see people have a few assets outside the trust for whatever reason. Maybe there's a car that was purchased or a bank account that was opened outside of the trust, or someone gets a insurance reimbursement or a tax refund after they pass, and we do need to open up the estate even though there's not going to be a lot of assets in it. Much better to have that happen, have a small estate. In many jurisdictions there's an expedited proceeding than to have everything out there and to be waiting on the court to sell an asset. For example, if you have your house in a trust, literally you can transfer title as soon as you have a death certificate and a new trustee appointed, and that can be often a matter of a week or so until you're able to transfer title. For someone who dies with just a will, or heaven forbid, no will at all, that process can delay the ability to transfer real estate by several months. And depending again on what time of year someone passes, right now we're in late October. Generally speaking, there's not a lot of activity around the holidays. People don't want to be moving around, Thanksgiving, Christmas, New Year's, and in the winter in general in the Northeast. So anything that you can do to move that process forward faster is going to save you money in terms of carrying costs. Carrying costs for a piece of real estate can be quite substantial, involving things like property taxes, insurance, those maintenance items and utilities. Often that can add up to several $1,000s a month, and is actually one of the biggest costs in estate administration. Speaking of cost, this is something that a lot of people ask about, and we tell clients that somewhere between 1 to 2% of the estate's value, and legal fees is usually a good ballpark number. Obviously, if someone has a lot of money in a single investment account and has a checking account, that's going to be a much simpler in administration than someone who has multiple accounts with multiple advisors or owns multiple pieces of real estate. So if you're seeing this before a loved one passes, anything that you can do to reduce the number of accounts is going to make the administration easier. The other big factor is the number of beneficiaries involved. Obviously, an estate with a single beneficiary is going to be the easiest to administer, and one with several beneficiaries that all have to receive an accounting and sign off on the administration is going to be more difficult and more costly. So those three factors, number of pieces of real estate, number of beneficiaries, and number of accounts, those are the big variables that lead to cost. Sometimes we have disputes in estate administration, and usually we try to solve those quickly and avoid them in the first place by including no contest clauses in our wills and trusts. The next and final steps for the fiduciary, trustee, or executor is to provide an accounting to all the beneficiaries. Here's where we started. Here's the expenses that we had. Here's what's left over. Divide by the number of beneficiaries or at appropriate specific dollar amounts, and get them to agree that they all agree to the actions that the executor has taken. This can be done informally, and I would say 95% of the time we engage in an informal accounting process. If there's disputes, though, about the appropriateness of expenses, then often that involves going through what's called a judicial accounting, in which a judge can approve or disapprove of the expenses of the executor. Typically, once all of the accounts have been liquidated, real estate has been sold, we move to a preliminary distribution in which the beneficiaries receive the majority of their inheritance and hold back a bit depending on the size of the estate for any taxes that might be due, filing final tax returns, final legal fees. Tax returns that have to be prepared are often come in three categories. One is the decedent's final personal tax return for the year in course. Sometimes people are of modest means, don't have a lot of income. If they die in the early part of the year, they may not have to file a tax return for that year, but usually they haven't filed the tax return for the previous year. So final tax return, federal and state, for that individual. Then the estate and trust have income tax returns from the time of the person's passing until the time that all of the assets have been distributed or placed in non-interest bearing accounts. And then in some states and federally, you have an estate tax return. Currently, here we are, 2025, the limit is $13.99 million for an individual. Most estates don't reach that level, but if they do, there's a tax return that will need to be filed. Next year, the threshold is going to $15 million per person. Different states have different thresholds. Massachusetts starts as low as $2 million. Rhode Island is about $1.8 million. New York, a little over $7 million. Vermont is $5 million. So depending on which state you live in, there could be a state level estate tax return to file as well. Finally, once all the tax returns have been filed and the assets have been distributed, the estate of the trust can be closed. And usually estates kind of go out with a whimper. There's a few assets left to be distributed. A final shorter accounting is done for those final legal and tax compliance expenses, maybe any final filings with the court that need to be filed to close the estate. We collect what are called receipts and releases from all the beneficiaries, or we get a judicial decree closing the estate. It's a fairly straightforward process, and if you're careful and prepare well in advance, minimize the number of accounts, keep your beneficiaries to a minimum, don't name multiple fiduciaries that could possibly have arguments and disagreements, your administration is going to go smoothly and quickly as possible. Typically, though, you're looking at anywhere from a year to 2 years for an administration, usually depending upon when the person passes away. If they die early in the year, you might get it done within the space of 12 months or so. If someone passes later in the year, you're probably looking more at the 1.5 years to your timeline. Anyway, any questions about your administration, please give us a call, 844-50-TRUST, and we'd be happy to help.